Kenosha shooter, Kyle Rittenhouse, he murdered 2 people, by the way.
Rittenhouse is basically what you would have had in a school shooter. He's a 17-year-old kid. He shouldn't have had a gun. He crossed state lines to supposedly protect property. No, he was going out to shoot people.
Kyle Rittenhouse, the 17-year-old vigilante.
Kyle Rittenhouse, a vigilante.
Kyle Rittenhouse, the armed teenage vigilante.
A 17-year-old vigilante, arguably a domestic terrorist, picked up a rifle, drove to a different state to shoot people.
Kyle Rittenhouse, a guy who's deeply racist, went with weapons to a Black Lives Matter protest looking to get in trouble. He did. He murdered a couple of people.
Rittenhouse, the 17-year-old kid, just running around, shooting and killing protesters.
You see the 17-year-old who was radicalized by Trumpism, took his AR-15 to Kenosha and became a killer.
That just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me.
So your interpretation of what he was trying to do or what he was intending to do or anything along those lines is complete guesswork, isn't it?
Well, he said, "Fuck you," and then he reached for the weapon.
When you were standing 3 to 5 feet from him with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
And there were... there were 3 people right there.
Take a deep breath, Kyle.
That's what I... That's what I run.
A criminal vigilante looking for trouble on the streets of Kenosha? A righteous citizen just looking to help his friends and neighbors? Or maybe just a naive kid who got wrapped up in a situation much bigger than he ever imagined? Welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. I've been playing with the idea of making this video for a while now, and I decided to go ahead with it. Now, this is a controversial topic that has captured the attention of the country during a time that divisive politicians, talking heads looking for media clout, and prosecutors who care very little about the facts run rampant in our society, looking for any opportunity to stir the pot. Going into my research for this case, I knew very little about it, other than just a few articles I had read over a year ago. My research included watching the original videos of that night's events, reading the police report, the pretrial motions, and watching all of the trial footage provided. This video will not show the original videos that include the shootings, and if you're wanting to watch those, links are provided in the description below, but we'll be taking a look at the events leading up to the trial and the trial itself based on the evidence that is admissible in court. First, in my opinion, the media's portrayal of this case was inflammatory. You had news outlets making wild accusations that were not necessarily true. There is a concerning pattern with our news media today that displays a report first, figure out the facts later type of mentality, which is dangerous, especially when a criminal trial is pending. People have a constitutional right to be tried by a jury in a courtroom setting governed by the rules of evidence, and to not be tried by talking heads reading off of teleprompters with half-baked conclusions, or to be judged by your favorite celebrity's opinion in a 140-character tweet. Responsible journalists should report the facts and allow the viewers to come to their own conclusions, which is a great time to remind you, I am not a reporter or a news outlet. In this context, I am a legally educated commentator who wants to spread a message of government accountability and transparency in the American sphere of influence. Next, a lot of this is truncated because there is simply so much information, so much testimony, and so much evidence that it would take forever to communicate it all effectively. Over 30 witnesses testified in a 2-week trial period, with each witness taking over an hour on the stand. So I'm hitting the highlights and encouraging you to do your own research if you find it interesting. Finally, I need to recognize my own preconceived biases. I am almost always criminal defense oriented. That means as soon as someone has been charged with a crime, I am naturally predisposed to find fault with the prosecution's case because I passionately believe in the fundamental value that you are innocent until proven guilty beyond a shadow of a doubt. The prosecution in every criminal case has a massive hurdle to overcome. It is their burden to prove that Mr. Rittenhouse is guilty. Not to prove that, well, he's probably guilty, or to prove that he kinda did something stupid, but according to the charges the prosecution filed, the prosecution must prove that he is guilty of murder. So what was Kyle Rittenhouse actually charged with? The prosecution filed 7 counts. Count 1, first-degree reckless homicide, use of a dangerous weapon. This count is in connection with the death of Joseph Rosenbaum. This is defined in Wisconsin Code 940.02 and is synonymous with other states' second-degree murder. The state must prove that the defendant caused Rosenbaum's death by actions that created an unreasonable and substantial risk of death or great bodily harm, that the defendant was aware of this risk, and that the circumstances showed Rittenhouse had an utter disregard for human life. Counts 2 and 3 are first-degree recklessly endangering safety, use of a dangerous weapon. Count 2 applies when Rittenhouse fired at Rosenbaum and Richard McGinniss was allegedly in the line of fire, while Count 3 is to an unidentified man who was fired upon later after attempting to kick Rittenhouse's head. Again, the burden is on the prosecution to show that Rittenhouse acted with utter disregard for human life. Count 4, first-degree intentional homicide, which is commonly referred to as murder, and requires the prosecution to prove that Rittenhouse intended to kill Mr. Huber. Count 5, attempted first-degree intentional homicide for the shooting of Mr. Grosskreutz, who was hit but survived the event. Then counts 6 and 7, which had to do with him possessing the gun as a minor and violating curfew, which were ultimately dismissed by the judge. The statute in Wisconsin is worded in a way so that a literal reading of the law would only prohibit minors from possessing short-barreled shotguns or rifles that are less than 16 inches long. Rittenhouse's AR-15 was exactly 16 inches long and allows him to legally possess it. Therefore, he was not guilty of this charge. So what happened the night of August 25th, 2020 in Kenosha, Wisconsin? Well, to be fair, we need to start 2 days earlier on August 23rd. At a time of intense social unrest, a police officer responded to a domestic disturbance and ends up shooting Jacob Blake in the back. This leads to mass protests that were responded to by officers in riot gear. Hundreds assembled to protest on the 24th, and it led to looting, violence, the streets literally set ablaze, and dozens of privately owned buildings being reduced to rubble. The following day, the owners of one of those private businesses that was at risk of being vandalized or destroyed solicited help from individuals to assist in protecting his property. One of those individuals was 17-year-old lifeguard Kyle Rittenhouse.
What are you doing out here? Obviously you're armed and you're in front of this business we saw burning last night, so what's up?
So people are getting injured and our job is to protect this business, and part of my job is to also help people. If there's somebody hurt, I'm running into harm's way. That's why I have my rifle, because I need to protect myself, obviously. But I also have my med kit. We're protecting from the citizens, and I just got pepper sprayed by a person in the crowd.
So you had non-lethal, but you didn't respond?
We don't have non-lethal.
So you guys are full on ready to defend the property?
Yes, we are. Now, if I can ask, can you guys step back? Medical, EMS right here. I'm an EMT.
The man filming the first part of this clip was Richard McGinniss, a video editor for the Daily Caller. He was one of the prosecution's witnesses during the trial, as he was an eyewitness to the first shooting that occurred when Kyle Rittenhouse shot and killed Joseph Rosenbaum. For those of you who have seen the video, Mr. McGinniss is the individual that literally takes the shirt off of his back to bandage Mr. Rosenbaum as he lays on the ground after being shot.
Mr. Rosenbaum advanced towards Mr. Rittenhouse. Mr. Rittenhouse gave I think he maybe saw him coming and gave kind of I said on the night of to police that it was like a juke, but it was more like just a pivot and a run.
Please continue. What happened after that, as far as you recall?
And then he pivoted and he ran towards this parking lot right here. So he was like right on the side of the street, and he ran towards this lot, and Mr. Rosenbaum ran after him, and I was behind both of them.
So the sequence of the folks that were involved in this running, as we've seen in many other videos, is Mr. Rittenhouse is in front, Mr. Rosenbaum is running after him, and you are behind Mr. Rosenbaum. Is that fair to say?
Yes.
Mr. McGinniss is not a sympathetic witness to the prosecution, so it's a little unusual that he would be chosen to testify by the prosecutor. However, the prosecution absolutely needs him to establish two things. First is for count 1, that Rittenhouse used his gun to shoot Rosenbaum with utter disregard for human life, and second, that Rittenhouse used his gun to recklessly endanger Mr. McGinnis's life in the process of shooting Rosenbaum.
And you continue to be behind Mr. Rosenbaum at the time that the defendant shot and killed him, correct?
I did alter my trajectory a little bit when I saw Mr. Rittenhouse turn around and saw Mr. Rosenbaum lunging for the front portion of the rifle.
What I'd like you to do, Mr. McGinniss, is tell the jury your, in your own words, what was going on at this particular moment where we stopped in the video.
So basically, I was running behind Mr. Rittenhouse and Mr. Rosenbaum, and like I mentioned before, Mr. Rittenhouse turned around and Mr. Rosenbaum continued, and I was continuing, but then I realized, that they were about to basically collide, and so at that moment, I was still running, but just before the shots, I kind of altered my trajectory of my run a little bit in the direction that I perceived to be out of harm's way.
What do you mean harm's way? You were several feet away from them. What was the harm to you?
Well, once Mr. Rittenhouse turned around and Mr. Rosenbaum continued, it was a very short, very, very short period of time from when he turned around to when the shots were fired. And basically in that very short period of time, I realized that Mr. Rosenbaum was continuing to advance, and that Mr. Rittenhouse was standing still, and that they would be, based on Mr. Rosenbaum's, the way that he was running, and then eventually lunging towards the front portion of the rifle, it was clear to me that something with the weapon was about to happen, and I didn't want to be on the wrong side of that.
When you say something with the weapon was about to happen, what do you mean?
Well, it wasn't clear to me whether the weapon would be grabbed or fired or what exactly was going to happen, but it was clear to me that it was a situation where it was likely that something dangerous was going to happen, be it Mr. Rosenbaum grabbing it, Mr. Rittenhouse shooting it. I didn't know, but I knew that my eyes at that moment were, like in this exact moment, were fixated on the barrel of the weapon, because I didn't want to end up on the receiving end of that.
You said your eyes were focused on the barrel of the weapon.
Yes.
Where was the barrel of the weapon pointed?
At this moment, when he stopped, it was aimed about 45 degrees at the ground.
Did you feel that the defendant's actions of turning around and pointing the gun and discharging those rounds put you in danger?
I would say that given where I was, certainly I was in danger, yes.
Let me back up 1 second. We've talked a lot about Mr. Rosenbaum's actions towards Mr. Rittenhouse, and I just want to clarify one part of that. At any point, did you see Mr. Rosenbaum touch the defendant's gun?
It's hard for me to say whether he actually made contact with the gun. But what I can say is that they were extremely close, and that if he did, then it didn't alter the trajectory of the weapon. So if he did, it wasn't like, he got a hand on it. It would maybe barely grazed it, but they were very close.
The eyewitness who was first on the scene to assist Mr. Rosenbaum and saw the entire incident just testified that Rosenbaum pursued Rittenhouse, that Rittenhouse attempted to disengage, that Rittenhouse pointed the gun at a 45-degree angle towards the ground, and despite this, Rosenbaum continued advancing towards Rittenhouse and lunged for the front part of the gun.
Is it hard for you to see that?
I certainly don't like to watch it.
I understand. I wanted to show that to you because there's a moment after the shooting where you are taking your shirt off. Why did you do that?
Because I presume that, given how close they were, that he had been hit, and that my dad was an ER doctor, and if something's bleeding, you apply pressure. So that was the goal with doing that.
We see in the video that the defendant runs around the cars and comes close to you. And again, like I said earlier, we're going to try and go back to that moment in time. I know, benefit of hindsight, but at that particular moment as you're standing there next to Mr. Rosenbaum's body, did you know that was the defendant?
I did not.
What did you think was going on with that figure next to you?
Well, the way that I saw it from, it was kind of a tunnel vision situation. So I was looking at Mr. Rosenbaum on the ground and attempting to find where the wounds were, and it was like a pair of legs arrived next to me from my peripheral vision, and I just screamed, "Call 911." And then I saw a hand reach into the pocket, and I assumed that that was what was happening. And actually, when I got up, I did, watching the video after the fact, I was facing Mr. Rittenhouse, but given that I was in the process of removing my shirt, I was actually looking at the ground, and I told the police, and I actually remember the moment the next morning that I realized that that was Mr. Rittenhouse when I saw the video.
If you had known in that moment that that was Mr. Rittenhouse, would you have felt in danger?
I think I felt in danger anyways, but I certainly, I think, would have maybe changed my tone of voice. I can't really imagine what I would have done, but I mean, I was afraid in that moment anyways, so it's hard for me to say.
The prosecutor has two things he desperately needs McGinniss to tell the jury. The first is that Rittenhouse acted unreasonably when he shot Rosenbaum, and the second that Rittenhouse's behavior with the gun made McGinniss afraid for his life. These statements would satisfy the elements necessary to convict Rittenhouse on counts 1 and 2. Unfortunately for the prosecution, McGinniss is providing the justification for Rittenhouse to act in self-defense and also not making it easy on the reckless endangerment charge, again shifting blame from Rittenhouse and onto the crowd and Rosenbaum. This gets to the point where the prosecution attempts to impeach the credibility of their own witness.
You have described your impressions of what Mr. Rosenbaum was meaning to do or intending to do in his final physical acts towards the defendant. Would you agree with me that you've given us your impressions of that?
Yes.
At any point, did you hear Mr. Rosenbaum say anything about the defendant's gun?
I did not know.
He never said, I want your gun, I'm going to take your gun, give me your gun, I'm going to steal your gun, anything along those lines?
I didn't hear anything like that, no.
And you've already established that after the shooting, Mr. Rosenbaum never says a word, correct?
Correct.
You don't know, as you sit here today, what Mr. Rosenbaum was thinking, do you?
You mean at the time of the shooting?
Yes. Or at any point in his life. I mean, you have no idea what Mr. Rosenbaum was ever thinking at any point in his life. You have never been inside his head. You never met him before. You don't know.
I've never exchanged words with him, if that's what your question is.
So your interpretation of what he was trying to do or what he was intending to do or anything along those lines is complete guesswork, isn't it?
Well, he said, fuck you, and then he reached for the weapon.
Let's talk about that. At that very moment, you've testified, the defendant has turned around facing Mr. Rosenbaum, correct?
Correct.
The defendant has the gun in his hand.
Correct.
Mr. Rosenbaum is advancing and is pretty close.
Yes.
Correct? You believe, you've testified, that Mr. Rosenbaum is reaching for the barrel of the defendant's gun. Is that right?
Yes.
There are many possible reasons why an individual in that position would be reaching for a gun that's pointed in their direction. Would you agree with me on that?
Well, to clarify, the weapon was at a 45-degree angle, approximately. I don't know what you're asking. If you're asking if there's a reason why he would grab it.
You've already given us what you think is the reason. I'm suggesting there are other.
When did I say that I gave a reason? I just said that what he was trying to do. I didn't give any reason on why he would. I have no clue. I will say that as many times as you want me to, but I have no clue why he was doing what he did. But I saw him go for the front portion of the weapon, and it was clear to me that that's what he was trying to do.
This is absolutely damning evidence to the prosecution's case on count 1. Remember, it is the prosecutor's burden to prove the defendant guilty, not to show some plausible reason that might justify why Rosenbaum lunged for the gun. We'll go over the rules of self-defense that were given in the jury instructions later on, but suffice it to say, you are allowed to defend yourself if you reasonably believe that you had to use deadly force to prevent imminent death or great bodily harm to yourself. Even if you are completely wrong about that belief, it is still a valid defense as long as that belief was reasonable. If someone has chased you down, yells expletives at you, and lunges at the front part of the gun that you are holding, it is reasonable to believe that that person is attempting to disarm you and potentially use that weapon against you. If the jury finds that to be a reasonable possibility, then they have a duty to find Rittenhouse not guilty on count 1. While there is no duty to retreat in self-defense claims in Wisconsin, retreating as far as you can before you use deadly force gives a good indication of the mental intent of the wielder of that force, which Rittenhouse's defense attorney explores a bit here.
He runs, according to your vantage point, basically as far as he can.
Yeah, I did state to the police the night of that it appeared that when he stopped, he entered an area where there was like a car parked and a wall. I mean, it would have been conceivable that, you could have, the car was like not, it wasn't up against the wall. Like you could conceivably have continued, but it seemed to me, my perception that night that he, had entered a bit of a dead end. or at least felt that way.
And Mr. Rosenbaum is running towards Kyle Rittenhouse, correct?
Correct.
And there's nothing between those two individuals to block Mr. Rosenbaum's view, correct?
Correct.
Could have stopped at any time once he sees an armed individual, correct?
I assume he could have, yes.
He kept advancing.
Correct.
And he continues to advance until he makes a lunge for the weapon, correct?
Yes, it appeared that he was lunging for the front portion of the weapon.
Okay, which would be the business end of an AR-15.
Yes.
And you know, as you sit here today, that he yelled the words F you, but the whole words, correct?
Yes.
Okay. What was the tone of his voice as he yelled that?
Very angry.
As he goes at Kyle Rittenhouse, correct?
Correct.
And there's been some statements about him shot in the back. Don't dispute it. If you're Mr. Rittenhouse and I'm Mr. Rosenbaum, did you ever see him turn away from you back to Mr. Rittenhouse?
No.
Okay. And your vantage point would allow you to see if in fact this is the proverbial shooting an innocent person in the back, correct?
You mean, was I close enough?
Yeah.
Absolutely.
Okay. And as he shot, you never saw him turn around, look at you directly, and begin running away for the back shot, correct?
Correct.
But in my best estimation, I think that the individual and possibly other individuals decided that they were going to get his gun from him. Do you remember telling Detective Sepperson?
I do, yes.
What was that statement based upon?
It was based upon the way that they were advancing towards him. It seemed that they were trying to move quickly, such that they could catch him.
Okay. Your statement, getting towards the end, and it was pretty clear to me that the guy with the gun was trying to evade the other guy, and that's throughout this event until he stops.
Yes, that's an accurate statement.
He did not want to be caught by Mr. Rosenbaum.
That is correct.
And when he finally did turn and point the gun, Rosenbaum kept advancing.
Correct.
And Mr. Rosenbaum had stopped 5 or 7 feet away from him. Would he have been shot?
I'm going to object, Your Honor.
I believe the defense missed a golden opportunity right here. While the prosecution correctly objected to the original question that if Mr. Rosenbaum had stopped 5 to 7 feet away, he would not have been shot, because that does create the need for the witness to speculate, and therefore he is not providing direct testimony. However, the defense could have introduced the same information he was wanting to elicit in an even more powerful form by asking McGinniss the simple questions: did Mr. Rittenhouse shoot Mr. Rosenbaum from 50 feet away? No. Did Mr. Rittenhouse shoot him at 25 feet away? No. Did he shoot him at 10 feet away? No. Did he shoot him at 5, 3, 2 feet away? In fact, Mr. Rittenhouse did not shoot until Mr. Rosenbaum was directly adjacent to him and lunging for the gun. Yes. I believe, based on the testimony presented to the jury and the evidence accumulated, that Mr. Rittenhouse should be found not guilty of counts 1 and 2. As of the creation of this video, the jury has entered their second day of deliberation, and the result is still unknown. Juries are unpredictable, especially with a case as volatile as this. So who knows what will actually happen? But in our next video, we'll evaluate counts 3 through 5 and take a look at the testimonies of Mr. Grosskreutz, the surprise testimony of Mr. Rittenhouse, and how the prosecution has already made several critical errors that could rear its ugly head in appellate court. I know this video was a lot longer in a different format than what we typically create, but let me know what you think. Did you like it? Love it? Hate it? Let us know in the comments below, and remember that no matter who you are, you have value and you have rights. Do not be afraid to use them, and we'll see you next time right here on Legal Dissent.